All right, we'll go ahead and get started. So thanks everyone for joining us today for December's Advocacy Ground Rounds with Doctors for America. My name is Reshma Ramachandran. I serve as the chair for the FDA Task Force for Doctors for America. For folks who might not be familiar with DFA, DFA is an organization, a nonpartisan organization of physicians and trainees around the country, representing about 27,000 across every state. The DFA FDA Task Force is actually a group within the organization that includes physicians across various specialties that focuses on strengthening and supporting the FDA to ensure our patients access to truly affordable, safe, and effective treatments. We're really thrilled today to have two experts on the Supreme Court cases that we'll be discussing today that will affect federal public agencies, including the FDA, but also have profound effects really on the administrative state across the board. So I'll go ahead and get started by introducing them. And again, today we're going to be talking about kind of the implications of cases around overturning the Chevron doctrine. So first up, we have Ms. Allison Sieve from Public Citizen. She's the director of the litigation group at Public Citizen, which is one of the nation's leading consumer advocacy organizations. We've worked with them quite a bit, including Health Research Group and also the Affordable or Access to Affordable Medicines campaign within Public Citizen. Her litigation practice addresses public health, including drug safety, food labeling and tobacco issues, consumer safety and consumer financial protection, open government, federal preemption, class action standards, and First Amendment issues. Basically, a lot of things that affect our daily lives have profound impacts on protecting the public. And many of her cases have involved issues related to the US FDA, as well as the US Department of Transportation, Department of Justice, and the Department of Health and Human Services, among other agencies. She's argued several cases before the US Supreme Court and many more in federal appellate and district courts. And we share an alma mater. She went to Brown University for her undergrad and also went to Yale Law School. And then we also have Mary Ruvelis, who's the Managing Counsel and Legal Advocacy Director at the American Cancer Society Cancer Action Network. She helped to create in 2001 in advising the American Cancer Society on tax and election compliance for its advocacy efforts. And in 2008, Mary founded and still directs their Judicial Advocacy Initiative, which recruits law firms to do pro bono public policy work to serve the organization's mission goals. The program has received millions of dollars in donated services, with experts assisting in a wide range of areas, from drafting regulatory comments affecting the conduct of medical research to court battles affecting access to health insurance and tobacco control. She's a member of the U.S. Supreme Court Bar, U.S. Court of Appeals for the D.C. and Fourth Circuits, the District of Columbia Bar, and the Virginia Bar, and has worked on numerous amicus briefs filed across these courts, including a brief that she'll be talking about today on behalf of the American Cancer Society Cancer Action Network, and in several landmark cases, including a number that I think DFA members are familiar with, such as King versus Burwell, which upheld the Patient Protection and Affordable Care Act. She also advises and serves on the Activism Advisory Committee for the National Multiple Sclerosis Society on how to use public policy to change lives of people with multiple sclerosis, and serves on the Board of Trustees from the McLean Community Foundation. Can't thank you both enough for joining us today. This is something I think all of us have been just talking about in kind of separate conversations, but have been kind of wondering why it's not gotten the attention of the medical and public health community more broadly, given what seems to be kind of profound implications on our clinical practice, medical medicine, and also public health. So I'll turn it over to Allison to give us an overview about Chevron and the cases before the Supreme Court.
Hi, and thanks for having me. I'm going to start at the beginning on the assumption that you all don't know what Chevron is, so maybe some of you do. Bear with me, we'll get to more specific applications to FDA and public health as we go along. So the Chevron case arose 40 some years ago out of a dispute over the interpretation of the Clean Air Act. And the contested statutory provision in the case required certain states to create permitting programs for certain stationary sources that emitted air pollution. In 1981, the Environmental Protection Agency issued a regulation that defines stationary source for purposes of the Clean Air Act, and the environmental group National Resources Defense Council, NRDC, sued the EPA, arguing that the definition of stationary source that the EPA had adopted violated the Clean Air Act. Little fun fact, the administrator of the EPA at the time was Justice Gorsuch's mother, Ann Gorsuch. In the end, the Supreme Court unanimously ruled for the EPA against NRDC and held that EPA's definition of stationary source was a permissible construction of the statute, and therefore the court would defer to the EPA. So in reaching that unanimous conclusion, the court explained that the Supreme Court explained that when any court reviews an agency's interpretation of the statute that the agency administers, the court should start by asking whether Congress has directly spoken to the question at issue. And if Congress's intent is clear, looking to the plain language of the statute, the context, and the statutory purposes, then the court should give effect to that sort of unambiguous intent of Congress. But if the court determines that Congress hasn't directly answered the question, the Supreme Court said that a court shouldn't simply impose its own views on the statute, but rather, if the statute is silent or ambiguous about a particular issue, then the court should consider the agency's answer, consider whether the agency's answer is based on a permissible construction of the statute. And if it is, then the court should adopt or bless or defer to the agency's interpretation. So in that case, after saying the meaning of statutory source wasn't clear from the text, and the EPA had advanced a reasonable interpretation, the court deferred to it, in part in light of policy concerns about second-guessing the agency in an area that Congress had delegated to the agency to decide. At the time, Chevron was not actually, so whenever I say Chevron, I mean Chevron deference. But at the time, Chevron deference was not, or Chevron was not considered really a watershed case. But since then, citations to Chevron and relying on what is sort of its two-step framework has become a staple of administrative law. That is, law about agency practice and judicial review of agency practice. So courts deciding cases concerning an agency's interpretation of a statute that the agency administers will often refer to Chevron step 1 and then Chevron step 2. And step 1 is asking whether the statute's meaning is clear, just looking to language, context, etc. If it's not clear, then step 2 is asking whether the agency's interpretation is reasonable. And because the agency wins if its interpretation is reasonable, even if it's not the best reading of the statute, step 2 is what we refer to as according Chevron deference. So when we talk about Chevron deference, that's how we got there and what we mean. So over the next 40 years, the Supreme Court has cited Chevron and relied on Chevron many times. The court has also ignored Chevron many times in cases where the parties thought it might play a role. Some scholars have done some empirical analysis that suggests that Chevron actually has very little impact on how the Supreme Court decides cases. But most cases never reach the Supreme Court, and Chevron deference has had its biggest effect in the lower courts. The district courts and appellate courts, particularly in DC, which hears most challenges to agency action, those courts have cited it thousands of times and relied on it to decide cases before them. According to one study where courts reach step 2, that is, find a statute's ambiguous and therefore consider whether the agency's interpretation was reasonable. In those cases, the agency wins more than 94% of the time. which is far more often than when courts don't apply Chevron. If the court resolves it at step one, looking to the plain language of the statute, agencies win more like 30% of the time. So it's important to note that Chevron deference really favors the agency. And so it's a fair weather friend for anyone outside of government, whether industry, regulated parties, or environmental groups or public health groups. When you like a regulation, then Chevron is your friend. And if you dislike agency action, then Chevron hurts. And the Chevron case itself illustrates this point, although NRDC likes Chevron now and has filed a brief in the case on the side of supporting Chevron, that is in the currently pending case. You know, NRDC lost the Chevron case. They were the losing party in the Supreme Court. In addition to its effect on judicial review, another noteworthy effect of the Chevron case is the effect that it, along with other sort of basic principles of administrative law over until recent years, have the effect on the rulemaking process. So in litigation challenging agency action, the agency can rely only on the reasoning that it offered during the rulemaking process. And so agencies write their proposed and final rules with an eye towards Chevron, and as well as other cases about judicial review. That's a good thing because that prompts a full explanation for the public. Over the past maybe 10 years and increasingly, sort of increasing pace since then, Chevron has become pretty controversial. And that's in part because of a larger ideological effort to undermine agencies' authority and agencies' ability to issue public health and safety and environmental and financial protections. And with an increasingly sympathetic Supreme Court, that effort has resulted in all sorts of challenges to agency authority. But more specifically, with respect to Chevron, it is also controversial in part because over the 40-year history of Chevron deference, agencies have claimed deference in court, and courts have sometimes given deference in situations that sort of exceed the scope of what the court described in the Chevron case. The Supreme Court did not mandate unqualified deference to an agency's construction of every statute in every case. Rather, Chevron properly applies only when a court concludes that Congress delegated authority to the agency and that the statute genuinely allows the agency to select among a range of reasonable choices to implementing the regulatory scheme delegated to it by Congress. Even when an agency has interpretive authority under the statute, however, sometimes it's the statutory text and background make clear that Congress meant either A or B. It didn't mean to delegate that question to the agency or anyone else. And if the statute really means A or B, and it's just unclear what Congress meant, if Congress just drafted poorly so its intent was ambiguous, but we know it meant one thing or the other, that's not really a basis for deference to the agency. But many courts, many decisions over the years, you'll see that courts defer to the agency just whenever a statute's ambiguous in any way or they're not sure what the answer is. And I think that the sort of overuse of deference is one significant reason why it became controversial. Mostly, though, it is controversial because it favors the government, and over time, especially during the Obama administration, various groups were unhappy about new regulation. We didn't have a lot of new regulation during the 8 years before that, and so When regulations started up again and courts were deferring to the agencies and challenges to those rules, it became Chevron became more of a focus of industry groups and libertarian groups. So now, coming up to present day, the Supreme Court has two cases that pose the question whether to overrule Chevron. The two cases are identical, so you might wonder why two. Justice Jackson was recused from the first case, which came from the DC Circuit, and she was sitting on the circuit at the time that the case was in the Court of Appeals. So when the Supreme Court had the chance to take a second case where all 9 justices could sit on the case, they granted the second one. There's no official document that says that's why the Supreme Court took the second case, but the popular wisdom is that they wanted a case where all 9 justices could sit instead of 8. In both petitions, which both challenge the same rule about fisheries, the petitioners in both cases asked the court to also consider the sort of specific rule at issue in that case and the holding specifically with respect to that rule. And in both cases, the court said, no, it took only the question that says, should Chevron be overruled? The specific application in Chevron in that case had to do with the courts had held that Congress was silent as to the specific question addressed by the regulation and therefore deferred. So one possible way that the court might rule is to just discuss whether Chevron applies in the cases where the parties agree that the statute was silent as opposed to ambiguous. I think there's a considerable amount of overlap, but there is some room there. One possibility is the court could just trash Chevron and say no deference. And another possibility, and one that we argued for in a brief the Public Citizen filed, is that the court could retain Chevron in a narrower form and just or in its original form, that it could remind courts that you don't defer anytime the answer isn't 100% clear to you, but you defer when you can identify that Congress delegated the agency to authority, delegated to the agency the authority to make the decision. And so the agency's exercise of that authority to make the decision would properly be subject to deference and properly within the scope of what the agency was supposed to do. Last, a word on what might replace it. If the court just overrules Chevron, there's another deference doctrine called Skidmore, which is referred to as deference to the extent the agency's position has the power to persuade. I don't know why that's called deference, because I think courts should always go with the position that they find persuasive. But it is at least a little thumb on the scale in favor of the agency, although not a full deference Chevron thumb. Another possibility is that judges will not give any deference to the agencies, and judges will just start making the policy decisions that Congress had delegated to agencies to make. Enough about that. And another option is that courts will apply sort of another administrative law approach, which is arbitrary and capricious review. Agency action can be challenged on the grounds that it is arbitrary and capricious, and there's factors courts consider to decide if it's arbitrary and capricious, but just the words themselves, arbitrary and capricious, tell you that it is a somewhat deferential standard of review. Like the agency wins not if it's what it's done is great, but what if it's done is not arbitrary. So it is possible, I think, that courts, lower courts in particular, that don't want to be policymakers could apply the standards of arbitrary and capricious review so that outcomes didn't differ all that much from what they are now. And with that, I guess I will return it to Reshma and Mary.
Thanks so much, Allison. That was really helpful and great in giving the overview. Mary, I'm going to turn it over to you, especially because you've been focusing on this in terms of the context of what this means for public health agencies, and would love to hear about the amicus brief that you filed along with the National Health Law Program.
Sure. Thanks, Allison, and thanks, Reshma. So based on that discussion, I'll explain a little bit about why public health organizations like the American Cancer Society and the American Cancer Society Cancer Action Network felt the need to engage. When she's talking about deference to agencies, remember that means all different types of executive agencies. So the Department of Health and Human Services, the bigger picture, but within that, Centers for Medicare and Medicaid Services, CMS, Food and Drug Administration, all kinds of health-related entities that basically really write all the rules for the business of what the practice of medicine is. And I'll sort of, this group does not need me to tell them that the practice of medicine and healthcare is probably the most highly regulated industry that we have in the United States. So if you like regulation because you think it makes things safer and it protects people, then you will be happy with the types of regs that these agencies are usually writing. If you tend to be much more laissez-faire and against, the administrative state, and I'll talk a little bit about that in a minute, you're going to be less happy about the fact that there's a sort of impetus towards deregulation going on. But anyway, so let me tell you a little bit about how the American Cancer Society, and I'll use that, actually both of our entities weighed in on this case, along with a bunch of other groups, and I'll tell you about some of those in a minute. But how do you weigh in on this case? Most of you, or some of you, might be familiar with the concept of an amicus curiae brief. I say that in quotes. Lawyers really like Latin. Amicus curiae means you are a friend of the court. Organizations or individuals files these briefs when they're not actually a party to the case, but they think there's something important at stake and they want to contribute to the debate. So one thing that most people don't know is that unlike legislators who can take meetings or go to public events to solicit opinion and that sort of thing, courts are not supposed to do that. They are actually supposed to base all of their, ruling in a case on what is officially submitted to them by various organizations and the parties in the case. So that means that if you have information that you think is important to a judge or the judges or justices when they're making a decision, you have to get in there as what they call amicus curiae. Otherwise, you're essentially not going to be heard. So there's an old Washington, D.C. quote that I've seen attributed to various sides that says, if you are not at the table, you are what's on the menu. And truthfully, that is what happens at the courthouse too. If you do not weigh in, whether if you're a party or not, you are not going to be heard. And so that gives very great incentive for organizations like the American Cancer Society that have something that we feel deeply about. And most of our briefs are scientific data and, based on evidence and research. But in this case, it was a little different, but we felt strongly that essentially you had a very important construct of administrative law that was at stake. So even though, Allison mentioned this is a maritime case, it has nothing to do, the underlying facts have nothing to do with ships. I'm sorry, with healthcare. They're about ships and, how people staff ships and whatnot. We care about the case because the principle at issue is so large that we felt we needed to weigh in. So the other reason groups file as amici is because it works. In a study spanning 10 terms of the US Supreme Court, the justices cited amicus briefs in over half of their written opinions. So not only were the justices reading these amicus briefs, they were citing them more often than not as authority in their opinions. So it's true that many times the justices use the briefs to bolster their existing views. But the bottom line is they are reading them and considering them. So when you see a statistic like that, you are, much more likely to want to weigh in. And that's actually what the leadership at the American Cancer Society and American Cancer Society Action Work has said is, look, we know these things work and we have a lot to say about certain cases. So what did the American Cancer Society and partners we recruited, like the American Heart Association and the American Academy of Pediatrics, have to say about Chevron deference? What was the best way for us to communicate our concerns and try and keep the doctrine in place? I have to give our outside counsel in the case credit. He advised staying away from the hot button issues like the environment or abortion in this brief. No, we felt the best strategy was to draw the justice's attention to the unnervingly massive amount of health law it probably hadn't considered, specifically giving deference to how the Centers for Medicare and Medicaid Services interpret the highly complex Medicare and Medicaid statutes. The intro to our brief said the following: overruling Chevron would have enormous impact on the administration of federal programs, including Medicare, Medicaid, and CHIP, that are critical to public health. Medicare provides health insurance coverage to approximately 65 million people in the US, comprising 57 million older adults and nearly 8 million younger people with disabilities. Medicaid and CHIP provide health and long-term care coverage to over 90 million low-income children, pregnant women, low-income adults, and seniors with disabilities. The competent and stable administration of these programs depends on the deep expertise of the agencies to which Congress has assigned the responsibility of promulgating rules and rendering interpretive decisions in connection with the implementation of these complex statutes, which serve nearly half the US population in every geographic region, of every income level, and with every kind of medical and care need. We went on to list 4 specific examples of cases where the lower courts used Chevron deference when interpreting statutes, not because Congress had shirked its responsibilities when it wrote the laws that were in question, but because there were basically zero chance the legislature could have anticipated the level of granular detail required to answer every single real world dispute. By most people's standards, these cases were mind-numbingly boring. They were about things like defining the terms proportion and factor under the Medicare statute for purposes of adjusting hospital payment rates to reflect area age-related costs, or agency rules clarifying that the provision of feeding assistance to nursing home patients without complicated feeding problems did not constitute the provision of nursing or nursing-related services under the Nursing Home Reform Act as incorporated into the Medicaid statute. It's just these sorts of esoteric questions courts should be deferring to the technical expertise of CMS on, and just the sort of case that if Chevron is overturned, the courts would surely have to hear again, as the monetary stakes are big enough that plaintiffs will be filing lawsuits all over the country. Our brief urged the court to consider these realities when looking at Chevron and not throw a hand grenade into the carefully crafted and highly complex web of healthcare regulations and statutes that underlie our healthcare system. Okay, we didn't actually use the term hand grenade in the brief. The American Cancer Society is way too dignified for use of that imagery in an amicus brief, but I wanted to make sure you all were still paying attention after all the legal jargon that Allison and I have thrown at you. The other thing I wanted to build on that Allison said was that the challenges to Chevron are part of a larger overarching strategy by certain groups to deconstruct the administrative state. And equally distressing to an evidence-based organization like mine is the trend to discredit science. In different amicus briefs, we have supported the Food and Drug Administration's scientific judgments in literally dozens of cases in which the agency is trying to get flavored e-cigarette products off the market, and supported its decision to approve mifepristone. We do not always agree with FDA. In fact, we've successfully sued the agency twice for shirking its duties to regulate tobacco products under the Tobacco Control Act, but we believe in much of what the agency does to protect the public. Rather than drone on, I want to thank each of you for your tremendous work as caregivers to our nation. We lawyers have our part to play, but we also have heartfelt appreciation for the tangible way in which you all save lives every day. With that, Allison and I are happy to answer your questions to the best of our ability.
Thank you so much. I mean, this is like really fantastic. I did have like some kind of initial questions based on some of the things that you raised. And actually, Allison, one of the things that you raised around Skidmore deference, just to be able to better understand, what would that actually like look like, or like what would be kind of the impacts of, let's say, instead of Skidmore deference taking over, instead of Chevron deference in administrative law, or thinking about these public health agencies? Like what would actually occur? What would be the implications on some of these agencies like FDA and CMS?
So I think that if the courts start applying Skidmore instead of Chevron, then the agency will lose more often. But because Skidmore is such a, I guess it would give in a best case scenario, it would give courts the ability to rule for the challenger as opposed to the agency in cases where the agency's interpretation really wasn't the best. Like, it wasn't crazy, it was reasonable, but it's not the best reading. So in some of the cases over the years, the public citizen has lost against the FDA, of which there have been many. Like, maybe we would have won because our reading was better, but they got Chevron deference. And for lower courts that don't really want to be policymakers, I don't mean all lower courts when I say that, for those lower courts that don't want to be policymakers, it would still give them something to rely on if they said, well, the statute is unclear, it could go either way, I'm finding the agency's view persuasive. So it's something to cite and to rely on, maybe even to try to do the same things they do now, but to have a different rubric for doing it. But for courts that don't like the idea that the government's job is to provide public protections for consumers, patients, and the environment, they could easily say that, you know, Skidmore isn't much. I don't find what the agency did persuasive. The industry is much more persuasive. So it's just if Skidmore replaces Chevron as the predominant sort of deference model, it gives the courts a lot of flexibility and really takes a lot of power away from the agencies. And I guess one more consequence that's worth mentioning is that Chevron deference just hasn't just, I think, prompted agencies to do a thorough job in the rulemaking so that they have a basis on which to defend it in court under standards like Chevron. I think it also helps to embolden agencies and make agencies feel confident about doing their job. So without Chevron, I think agencies will be much more hesitant to issue new regulations or they're not going to stop entirely, but they're not going to do bold things, even bold things that are fully within the scope of their delegated authority. And we know that because we've seen some of that happening even over the past 2 years, given the Supreme Court and sort of constant challenges in Texas to everything that agencies do, that we know from people in the agencies that there are things they would like to do, but they're really hesitant because they assume that it won't hold up in the current environment.
Yeah. Mary, did you want to add anything onto that as well?
Yeah, I mean, the only thing I'd add, because she covered it so well, is, you know, and I think she actually alluded to this in her remarks, is, you know, courts just ignore Chevron when they don't want to deal with it. So, I mean, I'll bring up 2 very specific examples of cases that we were heavily involved in, where the courts just essentially brushed Chevron aside. And the first was back in 2000, when the Food and Drug Administration asserted jurisdiction over tobacco products. And it was the case was in 2000. I think the agency asserted jurisdiction in 1995, and organizations like the American Cancer Society had been urging it to do that for a very long time. So we were very invested in the Food and Drug Administration being able to do that. And what was interesting was, you know, under Chevron, arguably because the statute, the Tobacco Control Act, or sorry, it was before that, it was the Federal Cigarette Labeling Act. Arguably, it was ambiguous on this point. You know, the FDA went ahead and did it. And the Supreme Court considered that. And by the way, the DC Circuit upheld it and said that, yes, the FDA does have the authority to do this. And I think they might have actually used Chevron. But then when it came to the Supreme Court, it was a 5-4 vote. So it was very close. And Justice Sandra Day O'Connor was the swing vote. And she basically wrote, well, we don't have to look at Chevron because the statute isn't ambiguous. It's very clear that the Food, Drug, and Cosmetic Act, that's what it was, the Food, Drug, and Cosmetic Act declares that the FDA must require that drugs and devices be safe and effective. And there's no way that tobacco can be safe and effective. So it just doesn't fit. So in that situation, basically they looked at Chevron and said it doesn't apply because the statute isn't ambiguous. They did the same thing more recently in the King versus Burwell case that you mentioned I worked on, where basically they just looked at the Affordable Care Act and they said, you know what, it's not ambiguous whether or not, the individual mandate functioned a certain way and whatever. This, it was a very esoteric issue that was going up in front of the court. About, well, anyway, so tax laws and building exchanges and whatnot. But what the court did was basically ignored Chevron and said, well, it doesn't really matter what the agency said because Congress was very clear. So, I mean, I think that's been a trend. So they don't actually have to overturn it. I mean, I think part of the concern that we as practitioners have with overturning it is if it's overturned, there are all these cases that could be brought to essentially relitigate things that were decided under Chevron. And what we have seen, over the past few years is I think lower courts are using it less because they're worried about getting, if it's overturned, that then they're going to see those cases come again. So I don't know if that's helpful, but that's the only thing I would add.
Yeah. One other thing that had come up in some conversations around like the administrative burden for agencies now to kind of explain more clearly, like why they have a particular authority, like why the statute may not be as ambiguous or might not be silent on certain issues. Can you talk a little bit about what that means in terms of, the implications on agency actions or their ability to do so, the chilling effect you kind of referenced as well?
I mean, they're supposed to do a well-reasoned job regardless. And, Allison alluded to, there's a whole nother statute, which, organizations can bring challenges under called the Administrative Procedure Act. That's different. But, I mean, so the agencies are supposed to be thoughtful and deliberative and sort of give the rationale for whatever it is they do. And there's this elaborate process of notice and comment, which, you might be familiar with. I don't know if your organization engages on that, but basically to build an administrative record. And usually, an administration can do a good job with that. And I'll certainly let Allison chime in. The one other thing I was going to say is I was in a meeting just last week about sort of what happens if Chevron goes down. And the other thing that would happen is it would be a very strong message to Congress that it needs to try and be really specific. And that's hard. Do you know what I mean? Because Congress has a very difficult time with some of the questions it's grappling with, even with respect to spending, which is sort of its primary, purpose is the power of the purse is kind of the single biggest one that has to happen all the time. And, that's difficult for Congress to do. So, I mean, to ask Congress to write laws with more specificity would be an outcome of this, but that would be very difficult in the current environment. Did you have anything to add to that, Allison?
Well, I'd say, first of all, that there's currently a 6-year statute of limitations on challenging final agency action. And so regardless of what happens to Chevron, regulations that were issued, I mean, there are sometimes shorter statute of limitations, but for FDA and HHS, it's generally 6 years. So regulations that are issued before 2017 or 2018 at this point, I guess, are beyond challenge as a case just challenging the statute. There's also another case pending in the Supreme Court that actually challenges the statute of limitations. But as of today, the courts apply a 6-year statute of limitations. So the effect is more forward-looking than backward-looking. I think King v. Burwell actually, to me, is a good example of when Chevron is appropriate and when it's not appropriate. The provision of the Affordable Care Act that they were focusing on in King versus Burwell had to do with taxes. And so what the Chief Justice said is Congress didn't delegate to HHS the authority to interpret tax provisions. They don't have no expertise with respect to taxes. And so we're not deferring to them. To me, that's an appropriate distinction of when Chevron should apply and when it shouldn't. If HHS had been, if what had been in front of them was interpreting substantive provisions about healthcare as opposed to the tax penalty, then they should have had deference. But in that, with respect to the tax provision, why would HHS get deference? So if they cut it back to what the chief said in King versus Burwell, then I think we would just be in a situation where we're having sort of a more principled application of Chevron. That would be fine. I don't really think that's at least what some of the justices have in mind. We know that at least some of them just want to get rid of deference entirely. When it comes down to it, whether we have 5 votes to get rid of it entirely, I don't know. I've heard predictions all over the place from, people who know a lot about administrative law, people who are sure that it's going down, and people who are sure that it's going to be totally upheld the way it is. There was another case about a different type of deference. There's another doctrine about deferring to agencies' interpretations of their own regulations, and about, I don't know, it was pre-pandemic, so 6 or 7 years ago, there was a case that challenged whether that type of deference should be overruled. It's based on a case from the late 90s, and people thought the court seemed unhappy with deference, seemed unhappy with agency action, and that type of deference, which we call our deference, was going down. And then it turned out the court just wrote an opinion that said, yeah, just like use it in a principled way. Don't go crazy with it. And nothing changed at all. I think everybody was on both, all along the political and regulatory spectrum were surprised. But when it came down to it, the court realized that its precedent made sense. So yeah, who knows? I mean, we'll have a better idea when we hear what the justices say at argument, but you don't really know until the decision comes down. One thing we can predict for sure is the decision will not be unanimous.
So we have a couple of questions in the chat. So one of the attendees says, like, thanks for a great session. They're asking actually, what does this mean for them as a cancer patient and the ability of the FDA to approve new medications for patients? The FDA oftentimes, writes regulations more broadly to kind of anticipate new innovations coming towards them as applications, and trying to be flexible and thinking about regulatory standards for approval or post-marketing requirements and such. So, would this have an impact potentially on how FDA even approaches, new health technologies or new medications that they're considering for market authorization?
So the decision shouldn't have an effect on individual approval decisions, because Chevron deference is about agency rules, and a decision about whether to approve a particular drug may get deference, like it's a scientific deference, but would not get Chevron deference because it's not an interpretation of a statute. But new agency guidance documents, new regulations, revisions of old regulations could certainly be affected. The FDA doesn't frequently issue new regulations about, like, drug approvals, for example, but it does sometimes. And it also issues the less formal guidance documents, which can also be challenged, although they're not binding, so maybe they're not as important. So I think it shouldn't have any, Chevron itself shouldn't have any like immediate, if it disappears, effect on product approval, except to the extent I think that it will make the agencies hesitant about everything. And then the FDA, when it comes to product approval, I think is caters more to industry than maybe it should. So it wouldn't normally have to the extent it's approving new products, there's unlikely to be a challenge. And I think that no one really would have standing to challenge an FDA decision to approve a product. So the question is about, I think, more about non-approval. I don't think Chevron will affect that so much. The mifepristone case might, which I assume everybody knows about, which really does challenges the agency's decision, it applying its medical and scientific expertise about the best way to, the best status for a drug. But Chevron, I think,
for a
won't have as much effect on the on specific product approvals. Mary?
Yeah, I was just gonna jump in and say, so I agree with Allison completely on that. And to crystallize the mifepristone, she alluded before to this other way that agency actions can be overturned, which is under the Administrative Procedure Act. And that's actually how the mifepristone, which is the abortion pill case, was brought. And the strong concern that organizations like the American Cancer Society have is when you have judges undercutting the scientific judgment of the FDA. So we have filed a couple briefs in that case. And essentially our underlying point is that scientific authority of the FDA is better than judges second guessing and making policy decisions, but also drawing an analogy from a patient perspective to say that the problem of judges yanking approval of drugs, which is essentially what happened in this case in the lower court, is that patients need to be able to rely on drugs. And, you know, whether it's an oncology drug or whether it's mifepristone, whatever it is, you know, patients need to be able to rely on it. And if you have something disrupting the science, which is essentially what, you know, these judges were doing, that is destabilizing and very problematic for patients. So the analogy we drew in our brief was to drug shortages. And as many of you know, that is a major drug crisis in the United States, is drug shortages, and drawing the analogy and some data on drug shortages to the situation of judges yanking approval. So I hope that's helpful.
Yeah, it's really helpful. And for folks who might not be aware on the call or who will be watching this afterwards, DFA has also been submitting amicus briefs on the mifepristone case and is planning to do so again at the Supreme Court, really talking about for clinicians what that also means in terms of FDA approval being challenged and the scientific evidence behind the approvals being challenged from a clinician perspective.
Yeah, the one interesting thing about that case is so much of the industry and the public health community are actually on the same side. So, you know, pharma filed a brief that Public Citizen largely agreed with, which is probably the first time that they've ever filed a brief that we agreed with. But the case is, you know, really is scary for reproductive health, but also has ramifications that are just go like well beyond that as well. If you can just file a lawsuit based on really no new evidence and get rid of an approved product.
Yeah, terrifying times indeed. Yeah. Just going back to the Chevron, and then I'll ask about kind of the larger administrative state like challenges that are occurring. You know, one of the other questions that came in the chat is that shouldn't the overriding principle, whether it's Chevron or Skidmore, be that the protection of public health and safety should guide decision making?
Perhaps oddly, the answer is yes and no. That, you know, the FDA or other parts of HHS and other agencies should always be acting to benefit the public, but they also can only act within the scope of the authority that Congress delegated to them. So, you know, in 1995, if there had been a provision in the Food, Drug, and Cosmetic Act that said tobacco is not a drug under the act, then even though the FDA's proposed rule on tobacco would have certainly been beneficial to public health and safety, it would have been outside the scope of their authority. So I guess I would just say, yes, I agree with the comment they should act for the protection of public health and safety, comma, within the scope of the delegated authority.
Mary, did you want to add anything else to that as well?
Sure. I mean, I would just say, I think what part of what was interesting too is, we've all over the last couple of years witnessed through the pandemic, a whole bunch of interesting legal challenges and cases that had risen, for example, I think it was CMS was basically issuing, was it CMS that was doing the ban on evictions? Do you know what I mean? You had never seen anything like that before, because that's just not something that that agency normally does. But you see these sort of unprecedented situations coming up, and what the rights of the agencies are and how it benefits the public and what the statute says are all this like ongoing interplay that constantly evolves. You know what I mean? I think what's interesting about this Chevron case is it's been around for a really long time, but it's still evolving. And so, we all sort of have to keep abreast of it. But from your members' point of view, I would say, hopefully nothing too crazy will happen, particularly with FDA approvals. I'm more worried about mifepristone than I am about Chevron, as Allison is.
I would say, though, the one reason that Chevron and other deferential court precedents, deferential to agencies are so important today is because I don't think ever had a more dysfunctional Congress. There's no substantive legislation that gets through. So I think really since early on in the pandemic, we haven't had much. Oh, sorry, the Inflation Reduction Act was pretty substantive, but for the past year at least, we don't have substantive legislation. So if a new scary thing happens, the agencies have to find ways to deal with it through the authority they have, like has happened with the eviction ban. Or eviction moratorium, because we have to assume, we know that Congress is not going to quickly pass new legislation to deal with all the things that have to be dealt with in a fast changing world. And they delegate authority to agencies so that they can do that. When the courts then sort of hamstring the agencies or have a presumption that the agencies shouldn't actually be taking steps to protect public health and safety, you have a real vacuum, and that's bad for public health, that's bad for the environment, that's bad for consumer finance, it's just bad. In some, that's bad.
Yeah. So it's kind of in the last few minutes, we've talked about some of these different sort of challenges that are occurring to undermine federal agencies' authority to protect public health. And I was hoping you could also talk about kind of the constellation of various challenges. Some of the cases that we've talked about before we had this webinar, like Braidwood versus Becerra, obviously with the mifepristone case that we've talked about, but kind of this attack on the administrative state and really undermining federal public health agencies and really just executive agencies altogether, and what this means, kind of looking to the future of how these agencies might operate. So Mary, I'll just start with you because to start. Yeah.
You all can tell me, are you hearing a lot of background noise for me? Can you hear me okay? Okay, good. Sorry, there's leaf blowing going on in my yard right now. So that's what I would say of all the cases that we've talked about, the one that has the clinicians associated with the American Cancer Society, the most up in arms is this Braidwood lawsuit, because essentially it's a constitutional challenge that would undermine the provision of the Affordable Care Act that requires most insurance companies to cover preventative services that are recommended by the U.S. Preventative Services Task Force, ACIP and HRSA, to cover these recommended preventative services without cost sharing. So as a health equity issue, that without cost sharing is huge, right? Because there are so many people that will not get their screenings if there's any cost sharing whatsoever. So, whether it's $20 or $200, especially the people that are lower end of the socioeconomic spectrum will not get their mammogram or their colonoscopy or their lung cancer screening, despite the fact that it's very good science and it's very good medicine and overall saves money because of these challenges. So that I won't get into the details of it, but that's the case that we're looking at. And we've been very heavily engaged with that case to try and essentially make the scientific arguments to the court about why these preventative services are critical and why people need to access them. So the crux of our brief in that case is all about science, which I think hopefully the courts will factor into their decisions. Was that clear on that? Okay. Allison, did you have any more to say about Braidwood? I know you all have waited too, right?
Yeah, so the Braidwood case was really a challenge by, sorry, I'm not going to characterize them, by a challenge to the coverage as preventive care of contraception and the drug PrEP to reduce the transmission of HIV/AIDS. So there are two sex-related drugs that people did not want at a particular company that covers its own employees. Healthcare didn't want to have to provide on a cost-free basis as is required.